ಆತ್ಮೀಯ ಬಂಧುಗಳೇ, ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟ ಐಲು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸಮಿತಿ ಪ್ರಸ್ತುತಪಡಿಸುತ್ತಿರುವ ಅಂತರ್ಜಾಲ ಉಪನ್ಯಾಸ ತರಬೇತಿ ಕಾರ್ಯಾಗಾರ, ಮುಖ್ಯವಾಗಿ APP ಮತ್ತು ಮುನ್ಸಿಪ್ ಪರೀಕ್ಷೆಯನ್ನು ತೆಗೆದುಕೊಂಡಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ವಕೀಲ ಬಂಧುಗಳಿಗೆ ಈ ಒಂದು ಕೋವಿಡ್-19 ಪ್ಯಾಂಡಮಿಕ್ನ ಭಾಗವಾಗಿ ಎಲ್ಲ ವಕೀಲರು ರಾಷ್ಟ್ರಾದ್ಯಂತ ಮತ್ತು ವಿಶೇಷವಾಗಿ ಕರ್ನಾಟಕ ರಾಜ್ಯದಲ್ಲಿ ನಾವೆಲ್ಲರೂ ಏನು ಕೆಲಸವಿಲ್ಲದೆ, ನ್ಯಾಯಾಲಯದ ಕಲಾಪಗಳಿಲ್ಲದೆ ಖಾಲಿ ಕೂತ್ಕೊಂಡಿರ್ತಕ್ಕಂಥ ಒಂದು ಸಂದರ್ಭದಲ್ಲಿ ಅಖಿಲ ಭಾರತ ವಕೀಲರ ಒಕ್ಕೂಟ ಈ ಒಂದು ಸುಸಂದರ್ಭವನ್ನು ಎಲ್ಲ ವಕೀಲ ಸಮುದಾಯಕ್ಕೆ ನಾವು ಒಂದು ಸಂದೇಶವನ್ನು ಕಳಿಸಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗಬೇಕು, ಈ ಸಮಯವನ್ನು ಸದುಪಯೋಗಪಡಿಸ್ಕೊಳ್ಳಿಕ್ಕೆ ಅನುಕೂಲ ಆಗಬೇಕು ಅನ್ನುವ ದೃಷ್ಟಿಯಲ್ಲಿ ನಾವು ಎಲ್ರಿಗೂ ಉಪನ್ಯಾಸವನ್ನು ನೀಡಲಿಕ್ಕೆ ಈ ಒಂದು ಅಂತರ್ಜಾಲ ಉಪನ್ಯಾಸ ತರಬೇತಿ ಕಾರ್ಯಾಗಾರದ ಒಂದು ವೇದಿಕೆಯನ್ನು ಸಿದ್ಧಪಡಿಸಿಕೊಂಡು ಆ ಮೂಲಕ ಯುವ ವಕೀಲರಿಗೆ, ಪರೀಕ್ಷಾರ್ಥಿಗಳಿಗೆ ಹಾಗೂ ರಾಜ್ಯದ ಎಲ್ಲ ವಕೀಲ ಮಿತ್ರರಿಗೆ ಕಾನೂನಿನ ಅರಿವನ್ನು ಮೂಡಿಸುವಂಥದ್ದು, ಜ್ಞಾನವನ್ನು ಹೆಚ್ಚಿಸುವಂಥ ನಿಟ್ಟಿನಲ್ಲಿ ಈ ಒಂದು ವೇದಿಕೆಯ ಮೂಲಕ ಸಾಕಷ್ಟು ಉಪನ್ಯಾಸಗಳನ್ನು ಸಂಘಟಿಸ್ತಾ ಬಂದಿದ್ದೇವೆ. ಈ ಒಂದು ವೇದಿಕೆಯಿಂದ ಕಳೆದ ಮೇ 26ನೇ ತಾರೀಕಿನಿಂದ ಪ್ರಾರಂಭವಾದಂಥ ಉಪನ್ಯಾಸಗಳ ಕುರಿತು ಈಗಾಗಲೇ ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಿಂದ ಹಿಡಿದು ಎಲ್ಲ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳು ಹಾಗೂ ಜಿಲ್ಲೆಯ ಪ್ರಧಾನ ಜಿಲ್ಲಾ ಸತ್ರ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಧೀಶರು ಹಾಗೂ ಎಲ್ಲ ಹೆಚ್ಚುವರಿ ಜಿಲ್ಲಾ ಸತ್ರ ನ್ಯಾಯಾಧೀಶರು ಹಾಗೂ ಕಿರಿಯ ಮತ್ತು ಹಿರಿಯ ಶ್ರೇಣಿಯ ಎಲ್ಲ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಧೀಶರುಗಳು ಅಲ್ಲದೆ ಈ ಒಂದು ವೇದಿಕೆಯಲ್ಲಿ ನಮ್ಮ ಪರಿಣಿತ ಹಿರಿಯ ವಕೀಲರುಗಳು ಹಾಗೂ ಪರಿಣಿತ ತಜ್ಞರುಗಳು ಸಾಕಷ್ಟು ವಿಷಯಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ತಮ್ಮ ಉಪನ್ಯಾಸವನ್ನು, ತಮ್ಮ ಅನುಭವದ ಅಮೃತವನ್ನು ಈ ಒಂದು ಉಪನ್ಯಾಸ ವೇದಿಕೆಯಲ್ಲಿ ನಿರಂತರವಾಗಿ 102 ದಿನಗಳ ಕಾಲ ನೀಡ್ತಾ ಬಂದಿದ್ದಾರೆ. ಆ ಎಲ್ಲ ಗೌರವಾನ್ವಿತರ ಉಪನ್ಯಾಸದ ಒಂದು ಧ್ವನಿಯ ಸುರುಳಿಯನ್ನು, ವಿಡಿಯೋ ರೆಕಾರ್ಡಿಂಗನ್ನು ನಾವು ನಮ್ಮ ಐಲು ಕರ್ನಾಟಕ ಅನ್ನುವ ಯೂಟ್ಯೂಬ್ ಚಾನಲನ್ನು ಪ್ರಾರಂಭ ಮಾಡಿದ್ದೇವೆ. ಆ ಐಲು ಕರ್ನಾಟಕ ಯೂಟ್ಯೂಬ್ ಚಾನಲ್ನಲ್ಲಿ ನಿರಂತರವಾಗಿ ನಡೆದಂಥ 102 ದಿನಗಳ ವಿಡಿಯೋ ಚಿತ್ರೀಕರಣಗಳನ್ನು ಈ ಒಂದು ಯೂಟ್ಯೂಬ್ನಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದೇವೆ. ಸಾಕಷ್ಟು ವಿಷಯಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟಂಥ ಎಲ್ಲ ವಿಡಿಯೋಗಳು ಈ ಒಂದು ಐಲು ಕರ್ನಾಟಕ ಯೂಟ್ಯೂಬ್ನಲ್ಲಿ ಲಭ್ಯವಿದ್ದು ತಾವು ಅದನ್ನು ವೀಕ್ಷಿಸಿ ಅದರಿಂದ ಹೆಚ್ಚಿನ ಜ್ಞಾನವನ್ನು ಪಡೆದುಕೊಳ್ಳಕ್ಕೆ ಸಾಧ್ಯ ಆಗ್ತದೆ. ಈ ಒಂದು ಯೂಟ್ಯೂಬ್ನಲ್ಲಿ ಬಂದಿರತಕ್ಕಂಥ ವಿಡಿಯೋಗಳು ನಿಮಗೆ ಲೈಕ್ ಆದಲ್ಲಿ, ನಿಮಗೆ ಅದು ಮನಮುಟ್ಟುವ ರೀತಿಯಲ್ಲಿ ಇದ್ದಲ್ಲಿ, ನಿಮಗೆ ಅದು ಸಂತೃಪ್ತಿಯನ್ನು ನೀಡಿದಲ್ಲಿ ತಾವು ದಯವಿಟ್ಟು ಈ ಯೂಟ್ಯೂಬನ್ನು ಲೈಕ್ ಮಾಡಿ, ಶೇರ್ ಮಾಡಿ, ಹಾಗೆಯೇ ಸಬ್ಸ್ಕ್ರೈಬ್ ಆಗಿ. ಇನ್ನೂ ಸಾಕಷ್ಟು ಹೆಚ್ಚಿನ ವಿಷಯಗಳನ್ನ ತಾವು ಪಡೆದುಕೊಳ್ಳಕ್ಕೆ ಈ ಯೂಟ್ಯೂಬನ್ನು ಫಾಲೋ ಮಾಡಿ. ಧನ್ಯವಾದಗಳು, ನಮಸ್ಕಾರ.
So I will come to the topic directly. So Code of Civil Procedure is a very, ಏನು ಹೇಳ್ಬೋದು ಅಂದರೆ, we go back to 1908 and if you start seeing the commentaries, ಅವಾಗ ಪಬ್ಲಿಷ್ ಮಾಡಿದಂಥ ಕಾಮೆಂಟ್ರಿಗಳನ್ನು ನಾವು ತೆಗೆದು ನೋಡ್ಲಿಕ್ಕೆ ಶುರು ಮಾಡಿದಾಗ what we find is ಅವಾಗಲೇ 1700-2000 ಪುಟಗಳ ಕಾಮೆಂಟ್ರಿಗಳು ಬರ್ತಾ ಇದ್ವು on the Code of Civil Procedure in 1908, 1909, 1910. So this is a topic which is very vast. And because it is really very vast, it is also a tough topic in that sense. It's much easier to pick up one particular order and then talk about it. But it's really going to be really difficult to talk about the statute as a whole. And because it's difficult to do so, I chose the difficult path, because we always grow when we choose something that is difficult. Whether as lawyers or for that matter, any other professional, we always grow when we choose something difficult and then take that path forward. To start with, we'll come to this 1908 Civil Procedure Code. And Sajbagi, people will have a question. Why do we need this code? Anta? Why do we really need a code like this in the first place? Well, to appreciate why we need a CPC, we have to imagine a scenario when we don't have a CPC, or for that matter, any enduring procedure to govern our courts. If we imagine a scenario where we don't really have such a procedure, what all can happen? We will find chaos, and we will also find that justice will lack something like predictability. And when that happens, that's not going to really be acceptable to the society. And that is why we need something known as a procedure to govern our courts. And those procedures, if you look into the jurisprudence that came out 150 years ago, 200 years ago, you will find that people were talking a lot about substantive law and they were emphasizing less on the procedural law. But in the last 200 years, we've seen a shift. The shift that we have seen is that substantive law, no doubt, is really very important, but at the end of the day, procedure makes a world of difference whether you can realize the benefits of the substantive law. So in that context, the Code of Civil Procedure as a procedure is there to, as the title or rather the preamble itself says, the purpose of this law is to regulate the procedure in courts of civil judicature. Now, the word civil judicature at some level recognizes the importance of civil courts because High Court of Civil Judicature, I mean, we've had this word judicature come in our legal lexicon largely to denote a sense of respect to the courts concerned. Okay, now, when the C.P.C came in 1908, it was made applicable from the 1st of January 1909. And if you open up and see what was being said about C.P.C at that point of time, you will find that they were saying, the lawmakers were then saying that one of the reasons why this law will come not immediately, but it will take few months to come is so that we want lawyers to get used to it, so that they will also realize that there is not a very big breach from the previous C.P.C. The previous C.P.C was the C.P.C of 1882, the Code of Civil Procedure. We've had a Code of Civil Procedure. You should know that we've had, procedures to govern civil courts for a very long time. But then a code that largely applied to the British territory was the Code of Civil Procedure 1959. And then it was amended very repeatedly, and then sometime in 1877. And what you will find is 1882 Civil Procedure Code, by 1901, in that short time, it had been amended 17 times generally, and it had seen 7 local amendments. And that is when our lawmakers felt that we have accumulated too much of confusion in these courts, and what we have to do is to really come out with something that is simpler. So the Civil Procedure Code of 1908, many of us feel that it's quite complicated, but you should know this was meant to simplify the Civil Procedure Code that was already there in existence much prior to this one. So in that context, you might want to know, how was the Civil Procedure Code of 1882, or at least when this C.P.C of 1908 came, what was the scenario like? That law had about 680 sections and again several schedules. And what the C.P.C of 1908 meant to do is, they wanted to create all these enduring principles in the body of the code. And they also wanted to come out with these rules that might require amendment at the local level, amendment through the intervention of the court as rules, so that it will be much difficult to amend the body of the code, and it will be relatively simple or relatively not that difficult to amend the body of the rules. And that is the arrangement of this. And as you are more than aware, anybody that gets into practice in the civil courts will normally realize that it will take a lifetime to understand the Civil Procedure Code very well, because if we are expecting C.P.C ಬಗ್ಗೆ ನಾವು ಅರಿವು ಮೂಡಿಸ್ಲಿಕ್ಕೆ ನಮ್ಮ ಪ್ರಾಕ್ಟೀಸ್ ಮೂಲಕ ಮಾತ್ರ ನಾವು ಅರಿವು ಮೂಡಿಸ್ಕೊಳ್ಬೇಕು ಅಂತ ಭಾವಿಸೋದಾದ್ರೆ, it will take a very, very long time. And why does it take a very long time? Because we have 158 sections and we have close to 50 different orders. And there are some orders where the rules, for instance, Order 21 that deals with execution, we have almost 100 rules there. And for that reason, anybody who is keen to know what is there in the C.P.C should not just wait for his practice to teach him about it. He should make time for studying this, and he should try to understand it from an academic perspective, so that whatever he learns from an academic perspective he can readily employ in his practice. Nobody should say that ನಾನು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ಈ ಕಾನೂನು ಬಗ್ಗೆ ನಾನು ನನ್ನ ಪ್ರಾಕ್ಟೀಸ್ಗೆ ಅವಶ್ಯಕತೆ ಬಂದಷ್ಟೇ ನಾನು ಕಲ್ತ್ಕೊಳ್ತೀನಿ ಅಂತ ಯಾರಾದ್ರೂ ಒಂದು ವೇಳೆ ಮನಸ್ಸನ್ನ ಮಾಡಿದ್ರೆ, what they will also realize is, for a very long time you will find that if you have been in practice for 35-40 years, you will still realize that there are so many different provisions of the code that you never invoked. But had you taken a academic interest in those provisions, perhaps your practice might have really been very very different. Because as we will see, and the thing about COVID-19 is it's created this opportunity for lawyers to get together through these videos, which anyway was not happening earlier. So it's a great effort of AILU to bring so many different lectures together, and then so many different lawyers to meet through forums like this. And I'm very confident that these efforts by AILU and then other similar organizations will ensure that lawyers will become more aware of the laws that they are required to have an expert understanding of. So let me start with the C.P.C. And then I will say, when we are talking about the overview, what I want to emphasize here is this: why is the law like the way it is? Now, you can see a lot of books behind me, and anybody can buy a 3-volume or a 4-volume code of civil procedure and then get to know whatever he wants to know. But I can also tell you that if you start looking at these commentaries, you will realize that the possibility of really getting a conceptual understanding from reading commentary is quite low, because these commentaries are not really trying to tell you what is the conceptual background of any given provision, or for that matter, how that provision can be connected to different provisions. What they are really doing is bringing in different judgments and then telling you what has been decided in which judgment. And when you start focusing on what has been decided in which judgment, you're going to get lost, because that's never how you conceptually understand what is there in the statute. So let's focus on the statute. And while we are focusing on the statute, you might also see that, oh wait, this lawyer is saying this is the position, but I've read in some judgment that's not the position. If you've read in some judgment something else to be the position, you should know that I have no disagreement with that, but I am not going there. I'm telling you about what is there in the statute. And it's really very important for us to recognize what is there in the statute, because if we know what's there in the statute, we will also be in a position to appreciate what came in a judgment and why did it become a point for a reported judgment to come out. Okay, now we'll start. It does apply. The C.P.C. applies to the whole of India. You will find one exception clause. It says it does not apply. It applies to the territory of India excepting the state of Jammu and Kashmir. Now, this is something that you will find in any number of central statutes. And you will also understand that last year, sometime by the August 7th or 8th, sometime around that, we abrogated Article 370 of the Constitution, and accordingly, the state of Jammu and Kashmir loses its separate constitutional status, and it in fact becomes like any other state in this country. Of course, now that state has been broken up into 2 different union territories. You will possibly see very shortly that there will be some omnibus law that will remove these clauses. So at this point of time, the C.P.C. would apply across the country, including the state of Jammu and Kashmir. And of course, because I'm not very sure if that provision has been removed, but so long as that provision is there in any statute book that you buy and which is very recent, you will find that it continues to not be applicable, but it's a matter of time when that exclusion will simply be removed altogether. And the other thing is, it does apply from the 1st of January 1909, but then this was a 1908 statute, and they gave several months so that the lawyers could in fact recognize that this is really continuing from the previous law itself. They were not a very big breach. They in fact rearranged the different sections, and then as we've already discussed, they wanted this to look more concise and compact. So now we'll come to the definitions. When we come to the definitions that are there in the C.P.C, what you will find is this. We often don't look into these definitions at all. We always start with the substantive provision, and then when there is some confusion, we come back to a definition clause. But as far as the C.P.C is concerned, I think we'll have to take a very different approach. We had better start with the definition. Now, what are all the definitions and what are the terms that have been defined? So we'll start with the code. The code includes the rules. Well, now you know rules. We have 158 sections in the code, or known as the body of the code, and then we have the rules, and then we have forms. Now that's in Schedule 1. There were 5 schedules when this law came into existence, and at this point of time, we find that first schedule alone survives. Schedule 2, 3, 4, 5 have all been repealed. So code includes rules, and then comes decree. Now, all of us have to struggle to understand what's really the meaning of a decree. And, there are thousands and thousands of judgments that focus on the meaning of a decree and whether a particular adjudication is a decree or an order. And, a lot of commentators have asked, why did we get into this mess? And the possible solution or answer to that is, the way the C.P.C has been structured is, if appeal were to be permitted against every order that is passed by a civil judge or a civil court, the expectation was the lawmakers was that the appellate courts will be clogged in entirety, and we cannot allow that. And therefore, the idea was, let's ensure that appeals are permitted in sparing cases, and appeals are not permitted from interlocutory orders. Appeals are permitted from what can be thought of as a final adjudication, right? Of course, appeals are always permitted even from interlocutory orders, but that's really very limited. So ensure what a decree is, and you should know the default position is every decree is subject to appeal, unless it is stated differently in the body of the code itself or in any other law for the time being in force. So we have to make effort to find out what is a decree, and why does the C.P.C go to such a great extent to define what a decree is and then to distinguish it from an order. We all have to understand, we all have to learn how to distinguish an adjudication as to whether it is an order or a decree. But then you also will know that everything is an order. Anything that a judge does in court is technically an order. So the C.P.C wants to treat certain orders, or rather certain final scope reaching orders, as decrees. And how does decree define? Decree is defined as formal expression of adjudication by a court, which court, so far as it is concerned, conclusively determines the rights of parties with respect to all or any of the matters in controversy in the suit. We just found out what is the statutory definition of a decree. Now, by now, a lot of people will be thinking, oh God, this lecture is another boring instance. I would apologize if this lecture is boring, but then there's no way how we can make it really very exciting, because C.P.C is a very interesting subject, but it requires a lot of hard work and determination, and parts of it may seem very boring, but I think one has to endure even the boring parts so that it then gets very exciting moving forward. So how is decree defined? Decree is defined as formal expression. Now, what is a formal expression? I mean, can we think of an informal expression in a court? No, you generally can't think of an informal expression at all. Formal expression means that the court is taking a formal stand in the matter. It's not, something like a judge informally addresses parties and tells something. So it's a formal expression of adjudication. What is adjudication? For something to be adjudicated, there must be competing claims. Ordinarily, I'm trying to make it a bit simple and then trying to make it a bit layman friendly. the meaning of adjudication is when there are two competing sides that are pressing against each other, and then there is a competition between those legal claims, and somebody has to adjudicate. Adjudicate means to make a choice and say where the justice lies. So formal expression of adjudication by a court, right? Now, the word court is not defined in the C.P.C. at all. So the court, the meaning of the court will be, you treat it, let's treat it as a civil court. By a court, which so far as the court is concerned, now again, it's a adjudication by the court, and so far as that court is concerned, conclusively determines the rights of the parties. Now again, conclusively determines means what? What is the meaning of conclusively determines? It means that there is not really more to go in the matter, which means it is not something that's happening at an interlocutory stage. So conclusively determines the rights of the parties. Now, when we say parties, we have to imagine that there are parties on both sides, that there are a set of people that are opposing each other. Conclusively determines the rights of parties with regard to all or any of the matter in controversy. Again, all or any of the matter in controversy. Okay, what does it mean? You see, when somebody files a suit, he would have sought a large number of, he would have raised a large number of issues. He would have made several complaints in his suit, and then it is opposed by the defendant. The defendant will take his own defense. So what we find is there are a large number of issues for the court to decide in a very broad sense. But however, what decree, the definition of decree essentially sticks to is this: conclusively determines the rights of parties with regard to all or any of the matters in a suit, matters of controversy in a suit. So if a judge were to say that, look, Mr. Plaintiff, you have made 7 different claims in this case, and the defendant has in fact opposed each one of those claims. But what we are going, you've sought several reliefs, but then we believe that you are entitled to 1 or 2 reliefs only, and you have raised so many issues, but it is unnecessary for us to decide all of those issues. So when the court were to say so and then come out with a final judgment, that ends the matter as far as that court is concerned. And this is how decree must be understood as. And as we have discussed already, why we really need to worry about the distinction between a decree and an order is, a decree is by definition appealable. Now, you know that appeal is a creature of a statute. And you also know that nobody has a common law right to appeal. So, because civil courts are going to be plenty, civil suits are going to be any number, if the lawmakers would not have made this fine distinction between a decree and an order, what would happen is, given the complexity in litigation, a large number of people would have taken orders to the courts on appeal, and the appellate court would have said, should I entertain this or should I not entertain it? Should we not wait for the trial court to decide? These were all the difficulties we were seeing in the previous courts, and that is why the definition of a decree has been made more stringent in this court. Now, this court itself is more than 100 years. I mean, it's almost 112 years now. So that's how decree is defined. And then it says decree may be preliminary. Now, I also want to point out another thing. I'm not looking at any of the paper, or I'm not looking at any of the book, but I'll come to that going forward in the sections. I will really come to that. Now, these are things I'm saying out of my memory. And what I also see is we are already at 5:40, 5:45. I will take as much time as I want to, or for that matter, as the matter will require. But at the same time, if any of you feel that, sir, this is getting too boring, you also must tell us so that we can try and do something else. So that's the decree can either be preliminary or final. Now, if you remember, a decree is meant to be an adjudication that is supposed to be final. But then here it says the decree could be preliminary or final. And somebody might scratch their head and say, what is this? Why is the CPC taking such a contradiction in the very opening part? And you will find that when you move forward, you will find that the CPC does this. CPC does this at so many different places. The idea is that when a decree is passed by a court, it is final. But in the nature of certain litigation, the court may require to carry on further proceedings, but those further proceedings could be conceptually separated from the preliminary decree, so that the preliminary decree itself could be subject to an appeal by those who are aggrieved by the preliminary decree, while the court may carry on with the further proceeding based on, if there is a possibility of an intervention by the appellate court, then that may come in handy for the court to take the next step forward. Now, you might ask, what are the examples that we can think of? Partition. Again, there's no hard and fast rule that in every suit for partition, there should first be a preliminary decree and then there should come a final decree. It's not so. But what we do find generally is, in suits for partition, the courts would normally engage in two-step process. First, they come out with a preliminary decree, and this preliminary decree is a final decree itself so far as the matters it covers are concerned. If in the preliminary decree they are already alienating, if they are already pointing out what is a share, of the family members and so on and so forth, that's it. Now that is final. Now, what are they actually entitled to after having allocated their portion, to take accounts in the property and then to make a final determination? Those are the things to be done in a final decree proceeding. So you might ask, okay, now we have a preliminary decree, then later on we will have a final decree. What happens if the preliminary decree is not appealed against? Well, the law is so very clear. Moving forward, you will find that where a preliminary decree is not appealed against, then it becomes final, in the sense, after the court engages in a final decree proceeding and then comes out with its final decree, and somebody is aggrieved with that final decree, and he takes that final decree on appeal, he will realize that there is a limitation as far as he is concerned. He did not question the correctness of the preliminary decree, and therefore, when he questions the final decree, he will not be permitted to question the correctness of the preliminary decree, which means he has to take preliminary decree has correctly decided, and in the appeal taken against the final decree, he has to show that the final decree was not, assuming that the final decree was faithful to the preliminary decree, the judge made some error there, despite being faithful. Now, that's the kind of difficulty a person gets into if he does not attack a preliminary decree when, if he does not attack a preliminary decree when he should be attacking. And as you can see, the definition of the decree itself says a decree may be preliminary or final. And then comes, it is deemed to include the rejection of a plaint. Now, that's interesting. Because when a plaint is rejected, there really isn't an adjudication. In some cases, let's say if a plaint is rejected on the ground that it is barred by limitation, if the plaint is rejected on the ground that the court fee that has been paid is insufficient and an opportunity was given to make good that deficiency, and then the defendant and whoever does not make good that deficiency within the allotted time, or for that matter, if it is insufficiently stamped or if it is barred by some other statute. Now, these are the provisions you will find in Order 7, Rule 11. And that's a provision that's very often invoked. And when somebody invokes this provision and then the court were to reject the plaint itself, what the definition of decree says is, even the rejection of a plaint will amount to a decree. Again, because the definition of decree is such that stricto sensu it does not apply here, they say it shall be deemed. Rejection of a plaint shall also be deemed to be a decree. And what happens next? Next is, and the determination of any question under section 144. Now, What is this 144? 144 is, again, unfortunately, a less invoked provision of the C.P.C, and that is restitution. You see, where a decree is passed, I'm simplifying it because it's far more complex than that. Where a decree is passed, but then that decree is appealed, right? Or again, now you might say that every decree is by definition subject to appeal, but you will find in one section 144 the possibility that a decree is modified or reversed or interfered with in appeal or revision. And after it is interfered with, the court, which is the appellate court or the revisional court, finds that it has to be modified to such an extent that the person against whom it was passed might have already suffered a disadvantage in the terms of if the decree had been executed partially or fully. And because that can always happen, isn't it? Now you can think about a scenario where a decree is passed while it is subject to execution. It is also taken up on appeal, and then the law itself says mere pendency of an appeal does not amount to a stay. So if an appellate court or a revisional court were to modify or vary a decree, and then the person that has already suffered a loss is now given a certain benefit out of that appellate decree, then that person can always go back to the court which passed the decree and seek restitution, which is the court which passed the decree will then try to put him in the position had it not passed the first decree or the original decree, which in most cases might have already been executed or partly executed, and thereby the person had been put to a loss. Now, determination of any question under section 144 will also come within the definition of a decree, and the order against which an appeal lies as an appeal against an order. So we will come to that a bit later. And it also says order of dismissal of default. Now there are lots of times when suits are dismissed. It's not a plaint that is dismissed. A plaint is rejected. Plaint is returned. It's a suit that is sometimes dismissed. So suits are dismissed because the court would have directed certain things to be done, or for that matter, Order 9 of the C.P.C will tell you various instances where the court may decide that the suit must be dismissed. Now, if a suit is dismissed, then it's dismissed for default because somebody did not behave in the manner that was required of him. That is, somebody absented without due excuse or something like that. So that does not amount to a decree. And why that does not amount to a decree is because very often it is possible for the party in default to go back to the court which dismissed the suit and request that the matter be reinstated, that the suit be reinstated. And for that reason, decree would not cover a scenario where a suit is dismissed for default. And we have already discussed about preliminary and final decrees, and you will find that the definition of the decree also talks about when a preliminary decree, when a decree could be said to be preliminary decree. And the way it talks about is when further steps have to be taken to completely dispose of the suit, it's a preliminary decree. Whereas, when a final decree is one that completely disposes of the suit, and the definition itself says certain decree may be partly preliminary and also partly final. And then comes decree holder. Again, whoever is the one in whose favor a decree has been passed or an order capable of execution has been passed is a decree holder. And somebody will ask, wait, order capable of execution? What are these orders capable of execution? Of course, the C.P.C is such a situation where orders sometimes, or for that matter, depending upon the nature of the case, orders also could be executed. And where if orders are going to be executed, then there could be people that would benefit from the order being executed in not entirely, but then in a conceptual manner. So decree holder is one in whose favor a decree is drawn or an order capable of execution has been passed, and district has been defined. District court is not defined. District is defined. District is defined in terms of the local, the territorial limit of a principal court of civil original jurisdiction. And where a high court exercises that, then of course the district, the concept of district is much larger. And foreign court, you see, the C.P.C is not just for the citizens of India. There are several provisions within the C.P.C that talk about foreign aliens can always sue, in our local courts. For that matter, we have, before I come to the definition of a foreign court, I want to tell you that aliens could be of two types: friendly countries and enemy countries. Now, citizens of enemy countries have a certain disability in filing suits in India, but of course they can always do. Friendly countries, they generally don't have any disability in terms of filing the suit in India. So foreign court is a court which is established outside India. Again, I'm not going by the definition because when 1908, it was a bit different. So I'm telling you about the practical scenario today. A foreign court is one which is a court established outside India and not established by the government of India, or for that matter, by the authority of the government of India. And a foreign judgment is a judgment of a foreign court. And government pleader, you always understand what a government pleader is. High court, now you will see there's a definition of a high court, but then it's not really a definition, because you want to know what a high court is, you will have to turn to Article 214 of the Constitution of India. Article 214 of the Constitution of India says that there shall be a high court for every state. And every state, of course, also means in that context, even a union territory, because high court is the one that's a repository of various constitutional safeguards to our citizens. Every state, or for that matter, every union territory must have a high court. And one would have thought that the definition of a high court in C.P.C might, in fact, deal with the status of high courts as we have in our constitution. That's not the case. And in this context, you will also note that under section 122 and under section 129, there is this reference to high courts, but then when the C.P.C was drawn, there was this inferior and then a superior high court in one sense, but we don't have that under the Constitution of India. All high courts are equal in status. We have 24 different high courts at this point of time. So here high court means High Court of Calcutta in connection with something, and don't go by the definition of India. It's not helpful. Judge, we don't, this particular definition, judge means a presiding officer of a civil court. You will find that I think in only one or two places you will see that this definition really becomes important. Otherwise, nobody will get into doubt, or nobody will get into difficulty if they just ignore this particular definition. And a judgment. Now, this is important because there are a host of provisions of what is a judgment, what is not a judgment, and when a judgment can be delivered, and when a judgment is final, and what must follow a final judgment. And so in that sense, judgment is a statement of reasons or grounds of a decree or order given by a judge. Because we have cases where the judge had dictated, I mean, this was long ago, judge had dictated the operative portion, and the rest of it was dictated by the judge's assistant sitting in open court to the judgment taker. And that came up before the courts, and then the courts were, even in a case like that, the court had to say, oh no, this can't constitute a judgment, because judgment has to be the labor of a judge himself. He could always take the assistance of whoever, but then it has to be the outcome of the judge's thinking. So we can't have someone else write it for the judge. And legal representative, you will see, is so very important. While you move forward, legal representative as defined here as someone who represents the estate of a deceased person. And the natural question you're going to ask is, well, why does it matter in a civil court that we should bother about legal representatives in all cases? In some cases, like for instance, in a suit for defamation, let's imagine there is a suit for defamation. Some public servant will file a suit for defamation against a newspaper, and that person dies during the course of the proceeding. The question that naturally arises uh, is it possible to substitute that person with his legal representatives who could carry it on? The question may seem really very simple, but then you will find courts have struggled so much with this. And that's the person who substitutes the plaintiff in a case like that strictly is not a legal representative in terms of the C.P.C definition, because legal representative as it is defined here is a person who represents the estate of a deceased person, which means where a person is litigating in court and he is likely to become subject to a liability, then if he does die and if he leaves behind property, and if that property passes over to certain individuals, then that property should be equally subject to liability, and the legal representative will be answerable in respect of that liability. That's a concept, and that is why. And that is why this provision defines legal representative as someone that represents the estate of a deceased person, and it also goes on and says someone who intermeddles with the estate of a deceased person. Now, intermeddling means that somebody who gets involved. And moving forward, you will find in the C.P.C that a legal representative is liable to the extent of the assets or the property of the deceased, estate of the deceased. I mean, estate of the deceased is a term that's used, so let's stick to that. A legal representative is answerable to the court to the extent of the estate of the deceased that comes into his hands. Now, if he has spent a portion of it towards any other lawful purpose, then he has to give an account of how he did spend. And when a court demands from him and wants to know from him, look, so much of money has come into, so much of estate has come into you, and you have to give an account of it to us, he has to. If he fails, then the court can employ coercive measures against him. And imagine a scenario where the court is satisfied that the estate went to the hands of the legal representative, but the legal representative claims without giving us evidence or accounts that it has been applied for some other purpose. In an event like that, there are other provisions in the C.P.C that say that the legal representative will be proceeded against personally. Now, for him not to be proceeded against personally, he has to ensure that the estate that comes to him is properly accounted for. And in this context, I also want to tell you about other provisions in the C.P.C wherein if the heirs of a Hindu, that is, if the legal heirs of a Hindu deceased or the descendants, if they are the legal representatives and if they receive the estate, then they will be entitled to take up the defense that, when there is a debt or, when the estate is being applied to clear up a debt of the deceased, then they are entitled to take up a defense of what is available to them under the Hindu law. Now, you are more than aware that in the Hindu law, it is if the debt must be of a pious obligation, and if it is tainted with immorality, then the legal representatives may refuse to honor that. So those considerations will apply. And we have men profit. You're aware what men profit is. Men profit is wrongful possession. Now, often people think that it is used in, it does have a connection with immovable property, but then technically speaking, it's not necessary that the property in question must be immovable property. If you wrongfully take possession of a property, whether it's movable property or immovable property, then the court is entitled to disgorge from you the profit. Again, remember, not the entire revenue, the profit that you made from it, or you could have made with ordinary diligence. And the lawmakers decided that, look, let us also say that where the person in wrongful possession makes improvement on his own, and then the benefit of that improvement will not be treated as men profit. Now, men profit is we have thousands dealing with men profit, and it helps always to have a conceptual understanding of it. And movable property, what is movable property? What is immovable property? To understand movable property, we should always know what is immovable property. Immovable property is not defined in the C.P.C. It is not defined in the C.P.C at all, but it is defined in the Transfer of Property Act. And here in the C.P.C, movable property is defined, but then again, it is defined not in a descriptive way, but in a certain inclusive way. It includes growing crops. And you should know that there are provisions moving forward that will talk about when it comes to attachment of the property of a judgment debtor. Now we are ready to go to the definition of, judgment debtor is someone against whom a decree has been passed, which means he has to satisfy the decree, or against whom an order capable of execution has been passed. Now there are provisions moving forward, which you will see, where you will see that certain properties are not subject to attachment. And these are so very elaborate. You will also find what are the circumstances when growing crop can't be subject to attachment, right? If the judgment debtor is an agriculturist and so on and so forth. So it helps. I never expected that I will be stuck in the definition for an hour. And I wanted to take the audience through various provisions, but it never occurred to me that I will spend so much of time just in the definitions. But I would only request you all to bear with me, because if you have a conceptual understanding of the definitions, you will find it is so much more easier to understand the rest of the provisions. And I've heard a lot of experts say the same thing, that they say that, look, anybody who wants to learn the C.P.C has to spend a lot of time on definitions. A lot of other statutes, you can take the Income Tax Act or you can take the Companies Act, you can start reading the provisions and then come back to definitions as and when there is doubt. But as far as C.P.C is concerned, one always has to start with the definition, because if you reflect enough on the definitions, you will realize that you can understand the rest of the provisions, far more efficiently than would be the case otherwise. And order, again, what is an order? What if the law had said an order is something which is not a decree? Well, in fact, the law goes close to that. It says it's a formal expression of a court which is not a decree. So to understand an order, you need to understand what a decree is. And then to understand a decree, you don't need to understand what an order is. A decree stands on its own, but an order doesn't stand. The definition of an order doesn't stand on its own. It stands after you understood what a decree is. Because what is not a decree? If it's a formal adjudication by the court, then it's an order, right? And pleader. Now, when it comes to a definition of a pleader, we will realize that these are advocates, right? Somebody who can plead, essentially. When it comes to this pleader, the meaning is simple enough that it basically means that it deals with those who plead for another, right? You plead for some other person, so you therefore are an advocate. Now, we had these various concepts and distinctions of advocate, vakil, and so on earlier, but we don't have that now. So it's fair to say that at this point of time, pleader will simply be an advocate or another person who represents him, not as an agent, but then who argues for him. That could be the broader understanding we take from this. But you should also know that if you are a pleader in a civil suit, you're expected to be conversant with the facts of the case, and you may be subject to question by the court. Now, there are stages where the court may call the pleader and ask the pleader about certain doubts that the court has about the case of the plaintiff. Now, if the pleader is unable to answer it, then the court would say, call upon the party himself or herself to the court. But in actual practice, what we find is, if the court were to ask certain questions to the lawyer would say, I am not aware, I will take instruction and I will come back to the court. And that does not seem to really be the intent of the C.P.C. at all. And I will slightly digress it. The reason why I want to digress it because I've been a bit academic. So let's just come out of academics for a moment. We have 2.3 crore civil cases pending at this point of time. And by any measure, we must see that as a disaster. And I was telling you in the beginning, what would happen if we imagine a civil court without procedure and a civil court that feels free to carry out according to its discretion? What's the worst thing that can happen? We will have a couple of crores of cases. Well, we already have a couple of crores of cases today. And you might say, well, you know, this thing has always been there in this country. Why should anyone make noise about pendency in 2020? I'm really very sorry. Pendency was not a big issue long ago. And I am sitting right here in Bangalore, and a lot of my colleagues that are in the audience are also in Bangalore. We will realize that this was part of the princely state of Mysore, right? Now, princely state of Mysore had 10 districts. Bangalore was one of those 10 districts. And as far as this princely state was concerned, they used to come out with a gazetteer every few years. Now, I want you to know that in the 1891 gazetteer that was published for the Mysore state, there is a record of the judicial business from 1881 to 1890. And again, I've not just seen this one book. I also wanted to make sure that what I read, I mean, it was very shocking to me, and what I'm about to tell you, you will find that in the territory of Mysore, they had adopted the Civil Procedure Code of 1877. In 1881 and all, they were applying that. 25-30,000 civil suits were filed every year, and within 3 months, 96% of suits were disposed of. Within 3 months, 96% of suits were disposed of. And they were not dealing with the Civil Procedure Code that's drastically different from what we are dealing with today. And let's go back to 1925. In 1925, Rankin Committee report was lamenting about one thing. It said, look, if civil suits are going to be, new civil suits that will be filed in 1925 have no chance of being dealt with before 1927. 1927. They were saying cases are now lagging behind and it takes almost 2 years to complete civil suits. Now, where we stand at this point of time is civil suits drag on for 10, 15, 20 years. And in 1925, they were talking of an estimated period of 2 years as the average duration of a civil suit. And then in 1960s, they were talking about, you know, the Law Commission report that came out in those times were talking about 1 year in which a large number of civil suits were disposed of. And today, we are in 2020, and it's important for us to recognize that if we need our cases to move forward swiftly, then it can't be that we come out with the C.P.C. of 2021. It's not happening. It's not going to help. And I also take issue with the Commercial Codes Act of 2015. I can tell you, I haven't seen a bigger mess than that. It is a mess of the greatest order, and fortunately for me, I'm not going to cover that. I mean, my plan was never to cover that much about it, because if you take up a standard book on C.P.C. today, you will find that few insertions only were made by the Commercial Codes Act. But then the way the act is structured, and then the way it confuses things, and it creates more trouble. And in this context, I also want to talk about the Court of Small Causes. Court of Small Causes causes big trouble. Open up any of the C.P.C. Commentaries, and you will find plethora of cases on small causes courts. You can take up the Karnataka Small Causes Courts Act of 1964, and you will find that what cases the Small Causes Court cannot take cognizance of. You will find in the first schedule a large number of cases. Now, while the intention of the lawmaker is that small cause courts will deal with cases of a smaller value, you will find to make sense of what cases can be filed in a small cause court, you will need an extraordinary talented lawyer. An ordinary person would never be able to make sense of the small cause courts act at all, because he will find that to understand these kinds of suits that won't lie there, I need a very, very eminent lawyer. I need a very knowledgeable lawyer to make sense of it. And Section 7 of the C.P.C, Section 8 of the C.P.C talk about cases that cannot be taken note of by the small cause courts, number one. Number two, you will find that there are so many exceptions that have been crafted to exclude small cause courts from some of the provisions. And you take up the 2015 Commercial Codes Act itself, it actually talks of small cause courts whose pecuniary jurisdiction does not exceed rupees 250. Now, what I don't understand is, in 2015, where in India do you have a small cause court whose pecuniary jurisdiction does not exceed rupees 250? Now, that is in connection with Section 35A, 35A or B, in connection with which compensatory costs, extraordinary costs can be imposed by the court. And in that connection, the 2015 Commercial Codes Act goes on to say small cause courts whose pecuniary jurisdiction does not exceed 250 rupees, there you can impose 250 rupees, or you can exceed the pecuniary jurisdiction by 100 rupees. If the aim of our lawmakers was to make things simple, I can tell you they are not succeeding in it, because they are making life more difficult. And I will again transgress from this, and I will come to this discovery provision about which my friend Mr. Ravi Shankar S.S. spoke at great length. And I also want to say this: less than 1% of civil suits that are filed in the country make use of the discovery provisions. But then discovery provisions were created with a view to ensure that it is applied in majority of cases. When if you look at the notes, that deal with these discovery provisions, it was the expectation of the lawmakers that more than half of the civil suits must involve the discovery provisions of the C.P.C. Now, what is this discovery? And like I said, I'm digressing from this. I'm not taking from a chronological aspect. So, the idea that we have is, I'm in a civil suit. I'm a plaintiff. I have said cases. I've made my claims selectively. The defendant comes to the court. He makes his defense selectively. It is for the judge to deal with it and then to come out with a solution. I'm sorry. That was never, ever, ever the intention of the Civil Procedure Code. The Civil Procedure Code starts and ends with the assumption that everybody has a duty to speak. Everybody has a duty to speak the truth. And this might shock a lot of lawyers. This might shock a lot of parties into thinking that this is not how we understand the civil courts. Right? I have said what I wanted to say. If my case is not true, the other side has to produce documents to show that my case is not true. I'm so very sorry. This is a crude logic that we have, we gave up sometime in 1750s in this country. If you start looking at the courts of law that were set up after 1750s, sometime by 1770s, 80s and all, they were really emphasizing on the discovery. So you can now discovery provisions nododadre, ಈಗ criminal process ನಾವು ತಗೋಣ. For instance, ಈಗ ನಾವು criminal process ಅನ್ನು ತಗೊಳ್ಳೋಣ. So when we take criminal process, what we find is you have the right to remain silent. ಆರೋಪಿ ಆದಂತ ವ್ಯಕ್ತಿ ಮೌನವಾಗಿರ್ಲಿಕ್ಕೆ ಆತನಿಗೆ ಕಾನೂನು ಒಂದು ಅವಕಾಶವನ್ನ ಕೊಟ್ಟಿದೆ. ಬಟ್ the exact opposite anta helಬಹುದು is what happens as far as civil processes is concerned. Civil processes nalli ಎರಡು ಕಡೆಯವರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹೇಳಬೇಕಾಗತ್ತೆ, ಮಾತನಾಡಬೇಕಾಗತ್ತೆ, ಮತ್ತೆ ಸತ್ಯವನ್ನೇ ಹೇಳಬೇಕಾಗತ್ತೆ. ಯಾರಾದ್ರೂ ಒಂದು ವೇಳೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕೊಟ್ಟಂತ ಮಾಹಿತಿ ಅಥವಾ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಮಾಡುವಂತ ವಾದ ತನ್ನ ಬಳಿ ಇರುವಂತಹ ದಾಖಲೆಗಳಿಗೆ ತದ್ವಿರುದ್ಧವಾಗಿರುತ್ತೆ ಅನ್ನೋದಾದ್ರೆ ಅದನ್ನ ಈ ಒಂದು ಶಾಸನ ಒಪ್ಕೊಳ್ಳೋದಿಲ್ಲ. ಈ ಶಾಸನ ನಿರೀಕ್ಷೆ ಮಾಡಿರುವಂತದ್ದು ಏನಂದ್ರೆ, ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮಾಡುವಂತ ವಾದ, ಆ ವಾದ ಬಂದು ಆ ವ್ಯಕ್ತಿಯ ಬಳಿ ಇರುವಂತ ದಾಖಲೆಗಳು ಮತ್ತೆ ಆ ವ್ಯಕ್ತಿ ಪ್ರಾಮಾಣಿಕವಾಗಿ ನಂಬಿದ್ದಂತ ಒಂದು ವರ್ಷನ್ ಏನಿದೆ ಆ ವರ್ಷನ್ಗೆ ಪೂರಕವಾಗಿರ್ಬೇಕು ಅಂತ ಕಾನೂನು ನಿರೀಕ್ಷೆ ಮಾಡುತ್ತೆ. ಅಂಡ್ ದಟ್ ಈಸ್ ವೈ ಈ ಡಿಸ್ಕವರಿ ಪ್ರಾವಿಷನ್ ಬಗ್ಗೆ ಬಹಳಷ್ಟು ಒಂದು ವೇಳೆ ಚರ್ಚೆ ಆಗ್ಲಿಕ್ಕೆ ಶುರುವಾದಾಗ, ಯಾಕಂದ್ರೆ ನಾನು ಗಮನಿಸಿದ್ದೇನೆ, ಡೆಲ್ಲಿನಲ್ಲಿ ಕೆಲವು ಲಾಯರ್ಗಳು ಇದ್ದಂತ ಒಂದು ಸಭೆಯಲ್ಲಿ ಇದು ಸಣ್ಣದಾಗಿ ಇನ್ಫಾರ್ಮಲಿ ಚರ್ಚೆ ಆಗ್ಲಿಕ್ಕೆ ಶುರುವಾದಾಗ ಹಾಗೆ ಎಲ್ರನ್ನ ಕೇಳ್ತಾ, ಬೇರೊಬ್ಬ ವಕೀಲರು ಎಲ್ರನ್ನು ಕೇಳಿದ್ರು, ನೀವು ಕೇಳಿದಿರ ಇದ್ರ ಬಗ್ಗೆ ಅಂತ. 8 ಜನ ಇದ್ದವರಲ್ಲಿ 8 ಜನ ಹೇಳಿದ್ದು ಇಲ್ಲ, ಕೇಳೇ ಇರಲಿಲ್ಲ ನಾವು ಇದನ್ನ ಅಂತ. ಬಟ್ ದೀಸ್ ವೇರ್ 25-30 ವರ್ಷಗಳ ಕಾಲ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಆಗಿದ್ದಂತ ವಕೀಲರು ನಾವು ಈ ಡಿಸ್ಕವರಿ ಪ್ರಾವಿಷನ್ಸ್ ಬಗ್ಗೆ ಏನು ತಿಳ್ಕೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ಯಾರಿಗೆ ಆಗ್ಲಿ ಗಾಬರಿ ಯಾಕೆ ಆಗ್ಬೇಕಾಗತ್ತೆ ಅಂದ್ರೆ, ಈ ಕಾನೂನನ್ನ ಮಾಡಿದಂತ ಸಮಯದಲ್ಲಿ ಕಾನೂನು ಅಥವಾ ಮಾಡಿದ ಉದ್ದೇಶ ಹೇಗಿತ್ತು ಸಿವಿಲ್ ಪ್ರಾಸೆಸ್ ಅಂದ್ರೆ, ಪ್ರಾಮಾಣಿಕವಾಗಿ ವ್ಯಕ್ತಿ ತನ್ನ ಒಂದು ಕೇಸನ್ನ ಕೋರ್ಟ್ ನಲ್ಲಿ ನಡ್ಸ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾಗತ್ತೆ. ಮತ್ತೆ ಆತ ಹೇಳಿರುವಂತ ಪ್ರತಿಯೊಂದು ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ಪ್ರತಿವಾದಿಗಳು ಯಾರು ಇರ್ತಾರೆ, ಪ್ರತಿವಾದಿಗಳು ಅದರ ಸತ್ಯಾಸತ್ಯತೆಯನ್ನ ತಿಳ್ಕೊಳ್ಳಿಕ್ಕೆ ಆ ವ್ಯಕ್ತಿಯಿಂದ, ಒಂದು ಪ್ಲೇಂಟಿಫ್ ಕಡೆಯಿಂದ ಇರ್ಬೋದು ಅಥವಾ ಡಿಫೆಂಡೆಂಟ್ ಅಂದ್ರೆ ಆಪೋಸಿಟ್ ಕಡೆಯಿಂದ ಬೇಕಾದಂತ ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನ ಕೊಡಿ ಅಂತ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮನವಿಯನ್ನ ಮಾಡಬಹುದು. ನ್ಯಾಯಾಲಯಕ್ಕೆ ಈ ರೀತಿ ಪಾರ್ಟಿ ಆದಂತವರು ಮನವಿಯನ್ನ ಮಾಡದೇ ಇದ್ರು ಕೂಡ ನ್ಯಾಯಾಲಯವೇ ತಾನೇ ಖುದ್ದಾಗಿ ಆದೇಶವನ್ನ ಕೊಡ್ಬೋದು, ಪ್ಲೇಂಟಿಫ್ಸ್ ಕೊಡ್ಬೋದು. ಈ ಉದಾಹರಣೆಗೆ ಈಗ ಒಂದು ಪ್ಲೇಂಟ್ ತಗೋಣ, ಒಂದು ಫಾರ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಈಗಾಗಲೇ 20-25 ವರ್ಷಗಳ ಹಿಂದೆ ಒಂದು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಇತ್ತು ಅಂತ ನಾವು ಭಾವಿಸೋಣ. ಆ ಪ್ರಾಪರ್ಟಿಯನ್ನ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿ ಇದ್ದಂಥವ್ರು ಎಲ್ರಿಗೂ ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕೂಡ ಅಂದ್ಕೊಳ್ಳೋಣ. ಆದ್ರೆ ಆ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಏನ್ ಮಾಡ್ತಾರೆ, ಕೋರ್ಟ್ಗೆ ಬರ್ತಾರೆ. ಕೆಲವರು ಪ್ಲೇಂಟಿಫ್ಸ್ ಗಳಾಗ್ತಾರೆ, ಉಳಿದವರು ಡಿಫೆಂಡೆಂಟ್ಸ್ ಆಗ್ತಾರೆ. ಕೋರ್ಟ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೆ, ನಾವು ಮೊದ್ಲಿಂದನೂ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿಯಾಗೆ ಮುಂದುವರಿತಾ ಇದ್ವಿ, ಈಗಷ್ಟೇ ನಮ್ಮ ಬಳಿ ಒಂದಿಷ್ಟು ವೈಮನಸ್ಯ ಕಾಣಿಸ್ಕೊಂಡಿದೆ, ನೋಡಿ ನಾವು ಹಿಂದಿನ ದಾಖಲೆಗಳನ್ನ ನಿಮ್ಗೆ ತೋರಿಸ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಿ, ಒಂದು ವೇಳೆ ಅವರು ತುಂಬಾ ಹಿಂದೆ ಯಾವಾಗ ಪ್ರಾಪರ್ಟಿ ಆ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿಯಲ್ಲಿತ್ತು ಅಂತ ಸಮಯದಲ್ಲಿದ್ದಂತ ರೆಕಾರ್ಡ್ಸ್ ಗಳನ್ನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕೊಟ್ಟಾಗ ನ್ಯಾಯಾಲಯ ಗಮನಿಸಬಹುದಾದಂಥದ್ದು ಏನಂದ್ರೆ, ಇಲ್ಲಿ ಪ್ರತಿವಾದಿಗಳು ಮತ್ತೆ ಪ್ಲೇಂಟಿಫ್ ಅಂಡ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಎಲ್ಲರೂ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಆಗಿರೋದ್ರಿಂದ ನ್ಯಾಯಾಲಯ ಸಹಜವಾಗಿ ಪ್ರಶ್ನೆಯನ್ನ ಅವ್ರು ಕೇಳಬಹುದು. ನೀವು ಈ ಪ್ರಾಪರ್ಟಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂದ್ರೆ ನೀವು ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದೀರಿ ದಟ್ ಯು ಆರ್ ಇನ್ ಜಾಯಿಂಟ್ ಪೊಸೆಷನ್ ಅಂತ ಬರ್ದಿದ್ದೀರಿ, ಬಟ್ ಪ್ಲೀಸ್ ಟೆಲ್ ಮೀ ಈ ಸದ್ಯದ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಮತ್ತೆ ಸದ್ಯದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಗಳನ್ನ ತಗೊಂಡು ಬನ್ನಿ ಅಂತ ನ್ಯಾಯಾಲಯ ಕೇಳಬಹುದು. ಅಂಡ್ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಇಟ್ ಸೋ ಹ್ಯಾಪನ್ಸ್ ದಟ್ ಸಾಕಷ್ಟು ಬಾರಿ ಅಂತದಾಗೋದಿಲ್ಲ. ಯಾಕೆ ಅಂದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪದೇ ಪದೇ ಹೇಳಿದೆ, ಸಿವಿಲ್ ಕೋರ್ಟ್ ನ್ಯಾಯಾಧೀಶರು ತಾವು ತಮ್ಮ ಕೆಲಸವನ್ನ ಅಂಪೈರ್ ಅನ್ನುವಂತ ರೀತಿಯಲ್ಲಿ ಭಾವಿಸ್ಕೊಂಡು ಮುನ್ನಡಿತಾ ಇದ್ದಾರೆ. ಬಟ್ ಆದ್ರೆ ಅದು ತಪ್ಪು. ಅಂಪೈರ್ ಕೆಲಸವನ್ನ ಸಿವಿಲ್ ಕೋರ್ಟ್ ನ್ಯಾಯಾಧೀಶರು ಮಾಡ್ಕೂಡ್ದು. ಸಿವಿಲ್ ಕೋರ್ಟ್ ನ್ಯಾಯಾಧೀಶರು ಮಾಡ್ಬೇಕಾಗಿರುವಂತದ್ದು ಸತ್ಯಾಸತ್ಯತೆಯನ್ನ ಅದರ ಶೋಧವನ್ನ ಮಾಡುವಂತದ್ದು ಮತ್ತೆ ಸತ್ಯವನ್ನ ಎತ್ತಿಡಿಯುವಂತದ್ದು ಸಿವಿಲ್ ನ್ಯಾಯಾಧೀಶರ ಕೆಲಸವಾಗಿರುತ್ತೆ. ಮತ್ತೆ ಆ ರೀತಿ ಮಾಡ್ಬೇಕಾಗಿರುವಂತದ್ದೇ ಈ ಒಂದು ಕಾಯ್ದೆಯ ಅಭಿಲಾಷೆ ಆಗಿರೋದ್ರಿಂದ ಕಾಯ್ದೆಯ ಅಭಿಲಾಷೆಯನ್ನ ನಾವು ಮುರಿದಂಗ ಆಗುತ್ತೆ when courts don't ask questions. And let's take a business dispute. ಈ ಬಿಸ್ನೆಸ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅನ್ನ ತಗೋಣ. ಈ ಬಿಸ್ನೆಸ್ ಡಿಸ್ಪ್ಯೂಟ್ ನಲ್ಲಿ ಒಂದು ಪ್ಲೇಂಟಿಫ್ ಹೇಳ್ತಾನೆ, ಈ ರೀತಿ ನಾನು ಸಾಲವನ್ನ ಕೊಟ್ಟಿದ್ದೆ ಅವ್ರಿಗೆ, ಡಿಫೆಂಡೆಂಟ್ಗೆ, ಅವರಿಂದ ಇಂತಿಂತ ದಾಖಲೆಗಳು ನನ್ನ ಬಳಿ ಬಂದಿದ್ವು, ಅಂದ್ರೆ ಅವರು ಇಂಡೆಮ್ನಿಟಿ ಈ ರೀತಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಶೂರಿಟಿಗೆ ಈ ರೀತಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಡಿಫಾಲ್ಟೆಡ್, ಈ ರೀತಿ ಅವರು ಸಾಲವನ್ನ ಹಿಂತಿರುಗಿಸೋದ್ರಲ್ಲಿ ಡಿಫಾಲ್ಟ್ ಮಾಡಿರೋದ್ರಿಂದ ನಾನು ಬಂದಿದ್ದೀನಿ ಕೋರ್ಟ್ಗೆ ಅಂತ ಹೇಳೋದಾದ್ರೆ, ನ್ಯಾಚುರಲಿ ದ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಆಲ್ವೇಸ್ ಆಸ್ಕ್, ಅಥವಾ ದ ಡಿಫೆಂಡೆಂಟ್ ಕ್ಯಾನ್ ಆಸ್ಕ್, ದಯವಿಟ್ಟು ನಮ್ಮ ಮತ್ತೆ ನಿಮ್ಮ ನಡುವೆ ಈವರೆಗೆ ಅಂದ್ರೆ ನಮ್ಮ ಈ ಒಂದು ಟ್ರಾನ್ಸಾಕ್ಷನ್, ಯಾವ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅನ್ನ ನೀವು ನ್ಯಾಯಾಲಯಕ್ಕೆ ತಂದು ಪ್ರಸ್ತಾಪ ಮಾಡಿದಿರಿ, ಆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದ ಎಲ್ಲ ದಾಖಲೆಗಳನ್ನ ಈವರೆಗೆ ನಮ್ಮ ಇಬ್ಬರ ನಡುವೆ ನಡೆದಿರುವಂತ ಎಲ್ಲ ದಾಖಲೆಗಳನ್ನ ಹಾಜರುಪಡಿಸಿ ಅಂತ ಈ ರೀತಿ ಕೇಳಿದಾಗ, ಒಂದು ವೇಳೆ ಪ್ಲೇಂಟಿಫ್ ಸುಳ್ಳಿನ ಕೇಸ್ ಮೂಲಕ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬಂದಿರೋದಾದ್ರೆ ಅಲ್ಲಿ ಸಿಕ್ ಹಾಕೊಳ್ತಾನೆ. ಅಂಡ್ ಈ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ನ ಉದ್ದೇಶ ಇರುವಂತದ್ದು ಅದೇ. So this law does not expect people to lie. This law expects honesty to be the bedrock of all civil claims. And unlike criminal process or criminal law, where a defendant has the right to remain silent, in civil cases, nobody has the right to remain silent. And if he chooses silence, then he will allow an adverse inference to be formed against him, number one. Number two, the court may very well, at any point of time, require the parties who might have taken advantage of the court to be punished, or rather the court might require those parties to produce documents or other materials with a view to determine whether those parties have blatantly lied to the court. And I can assure all the viewers here, unless and until, I mean, if you are a civil judge, or if you are going to, or if you are a lawyer, your practice can never be meaningful if you are not aware of the discovery provisions, and if you do not employ these discovery provisions, because you will find out that in a in several Western countries, in civil processes, discovery is invariably applied. And if a lawyer does not apply discovery provision to his case, he probably will be viewed with suspicion. And if he is going to be sued by his client later for malpractice or negligence in conducting the case, the first question the Board of Discipliners will ask him is, there were the discovery provisions which you were required to invoke. Why did you not invoke? Why were you not eager to know the weakness in the other side's case? And in this context, I want to tell you that it is the Supreme Court of India itself which has said that one of the purposes of the discovery provisions is to ensure that a party will obtain material from the opposite side which could be detrimental or damage the opposite side's case. Now that's the scope of discovery provisions, and no document or nothing for that matter will ever be withheld by the other side on the ground that it could be damaging to him. And no court is going to say that I will not allow such a document to be produced in evidence because that document might be damaging to the party concerned. That's not the law that we follow at all. I'll give a practical example. We'll come to the Visakhapatnam LG polymers, chemicals or something that happened 1 or 2 months ago. And we had 11 or 12 deaths. Now, this is a wrongful death. That LG polymer factory, now we don't know if they obtained environmental clearance, if they obtained chemical, clearance from the chemical inspection officer or whatever. We don't know at all. Assume for a moment you're a lawyer and you have been approached by the legal heirs or the representatives of somebody who died in the Visakhapatnam tragedy. What would you do if you can establish on the face of it that your client happened to die due to the poisoning, the styrene, and the Visakhapatnam LG polymers let out this toxic gas known as styrene, and it was situated close to a residential locality, and that's really very surprising. You cannot, styrene is this offshoot of cigarette smoke also. It's toxic at a certain level, and when a factory is manufacturing styrene, then for 7 or 8 kilometers, normally residents, human habitation is generally not allowed within 7 or 8 kilometers. At least that's a law in European Union. So if you're approached by the family members there, and if you are able to show that the person who died due to the inhaling that toxic gas, what are you going to do next? How do you sue this factory when you don't know how exactly they were negligent, though you do know that they were negligent? So what you do is this: you will of course always write a letter, legal notice to the company stating, again, as far as I'm concerned, I believe in honesty is the best policy. As far as the legal profession is concerned, and as far as much more, more so the civil litigation, I can tell you honesty is always the best policy. So if you write a legal notice to the company stating that, look, there was a death and that was due to your negligence, and we want you to basically do X, Y, Z. Now, most likely you're going to seek compensation. most likely you're also going to seek an apology, and also you're going to seek from that company a cleanup effort. Let's assume this is what you want to do. And then the company doesn't respond to you. Then you go to the court. You're not going to go to the consumer court because, by the way, there's no consumer relationship here in the first place. But it's very unfortunate that we've seen in several cases that people approach the consumer court in cases like this. There is no consumer court dispute here, so you go to a civil court only. And when you file in a civil court, you're going to make the allegation that this company was negligent. Negligent why? Because they did not take steps to prevent leakage of the gas. Now that's what we know at this point of time, that gas leaked. And this gas was never meant to be leaked, right? Because these were human beings that were living around the factory. And so the factory had to be fortified in such a way. And if the factory presented a great harm to the people that were living there, the factory should have been removed from that place by the government. So you're suing that factory, and remember that factory does not have privilege, it's a private entity. If you sue that in a plaint, right, and if you institute a suit, what are you going to do next? You're going to ask from that factory through discovery all the documents that actually would show how much of care the company took with regard to preventing the escape of that toxic gas. You're going to ask, give us your emails, give us copies of your emails that you might have had at different levels, pointing out about, talking about what steps you need to take to make sure that the gas does not escape or breach this facility. Give us information about your inspections, give us information about who inspected it, give us information about what was the internal thinking in the company about the leakage of this gas, right? Now, these will all be the subject of a discovery. And when you start asking, I'm just keen to know, or for that matter, keen to speculate, LG company would not be in a position to say, no, we can't turn over any of this information because this will incriminate us. It doesn't matter. It doesn't matter at all whether it incriminates them or not. The document, they have a duty to turn over these documents. And if LG basically has a mischievous lawyer, that lawyer might also say, let us also actually invoke discovery provisions now, as far as you plaintiffs are concerned. Give us information about your house building plan. Now, what will you do? The lawyer for LG might say that, look, you were residing in an illegal house. Okay, your house did not have a sanctioned plan at all. You were never supposed to be there. If they were to say so, what would the court do in a scenario like this? My guess is the court might say, okay, LG is entitled to that information. Now, whether that information is relevant or that information is central to their defense, we will look at it later. But you may turn over that information is what the court is very likely going to say. But you should also know that you will, if you are the legal representatives of the family members of the deceased, you will know that LG's argument there does not hold much water, because it does not matter whether the house was legally constructed or illegally constructed, so long as it was open for construction. If that was a residential area where the government would anyway sanction a building, then it matters not that you did not obtain a permit from the government, because that played no part in LG's culpability, civil negligence here at all. So LG could always argue, however, that the building plan, had you secured a building plan, the building plan regulations require sufficient ventilation, and you constructed your house in such a way that there was no ventilation. Now, so long as LG cannot argue that much, you are, I think, essentially safe. The court may very well say, you provide information about whether you have a building plan, and certainly you should turn it over. You don't have to be afraid about it. And this is how it works in both ways. But eventually, who will prevail? In my view, I don't have even the slightest of doubt. All of those who died in that Visakhapatnam tragedy could in fact be compensated to such an extent that LG company could go bankrupt. but it's very unfortunate because the discovery provisions are not widely known. We do not create enough deterrent in such violators, right? So then I'll come back to the C.P.C. That we were talking about. Pleader, I said already that pleader will be someone who represents another not as an agent, but for argument and for such other issues. But a pleader is required to be very familiar with the facts of the case, because the court may ask the pleader about the facts of the case that he is pleading. And if the pleader says that he is not aware of it, then the court may very well say, call upon the party himself. And the court should be doing that more often. No party has a, if a party is swearing on an affidavit, then the party has understood that about what the party has said. And you will find in the C.P.C several places where women are subject to some privilege. Now, what is that privilege? If women who are generally not seen in public, if the process serving officer, or for that matter, an executing officer, or somebody who wants to seize movable property, or somebody who wants to attach an immovable property, in all those circumstances, if they realize that there is a woman inside who is generally by the custom not seen along outside, then they will request that woman that we will not come in, we will go away for a few minutes or maybe half an hour or 1 hour. We want you to leave the place without showing your face to us. So there are some small exceptions as far as women are concerned, but there is none so far as any women coming to a court, lying on an affidavit and then being free of consequences. There is none. And the C.P.C itself clearly says that you cannot arrest a woman judgment debtor on a money decree. Now, again, that's we also find that a number of women misuse that provision. But nevertheless, by and large, the C.P.C does not give any privilege to any person to lie to the court and to escape the consequences at all. So, public officer, you will know a public officer is defined in very expansive terms. Normally, who you think of as a public servant will be a public officer. And why do you have to know the meaning of this is because if you are going to sue a public officer in terms of section 80 of the C.P.C, on the ground that you have you have suffered damage because of a public officer's act, which he claims he did in discharge of his official function, then when you want to issue a notice, there is a modality issued that you have to come out with 2 months. You have to give a notice that will give them 2 months time and then file a suit. And you can only file a suit if it's a matter of grave urgency. And if it is a matter of grave urgency and the court agrees with you that it is a matter of grave urgency, then even then the court cannot pass an order ex parte against the defendants. They will have to still give them a small opportunity of showing cause. So in so many other places, the definition of public officer really becomes very relevant. And rules are all the rules that we will find in the first schedule. It includes the forums as well. And share in a corporation. Why should you worry about share in a corporation? That's because shares don't include debentures normally. Shares don't include debenture stock, or for that matter, bonds. But here, it's actually expanded. It says share in a corporation means shares, debentures, bonds in a company. And when it comes to attachment, this definition really becomes very crucial when you're dealing with attachment and when such of these products are involved. And subordination of courts, that's section 3. I've come to section 3 now. You see, the C.P.C is workable only if you can think about a hierarchy of courts. Again, please remember, when we talk about a hierarchy of courts, as far as the C.P.C is concerned, you could, for all practical purposes, ignore the Supreme Court. The Supreme Court has such a small role in the C.P.C, you could ignore it. Now, where exactly does the Supreme Court come in? Section 25 of the C.P.C talks about the power of the Supreme Court to transfer a civil case, appeal or proceeding from a civil court or a high court in one state to another state. And then the Supreme Court also comes in when a high court, when the high court, after it has dealt with a judgment or an order or other final proceeding in a civil matter, determines that it's a matter fit to be heard by the Supreme Court. It presents a substantial question of general importance. Now that's again important, a substantial question of law of general importance. And in the opinion of the High Court, the matter deserves to be heard by the Supreme Court. In that event, the High Court will make a request to will issue a certificate, and then the Supreme Court will deal with the certificate. And there is another provision in the C.P.C. that says nothing in the C.P.C. will take away the power of the Supreme Court, which it has under Article 136 of the Constitution. So, while you're dealing with the Constitution of India, you find this hierarchy of courts starting from the Supreme Court of India, the high courts. Every state must have a high court, followed by what? The district courts. Because every district, it so happens that we are fortunate, every district would have a district court. And then within a district, you will have inferior civil courts. Now, the civil judges, the Karnataka Civil Courts Act of 1964 initially had the civil judge senior division, civil judge junior division, and sometime in 2009, this distinction was abolished, and then in name only, abolished in name only, it's a senior civil judge or a civil judge, and then again a smaller forum, that's a court of small causes. Now, as far as the C.P.C. is concerned, you could largely keep out the role of the Supreme Court. Like I said, Supreme Court's role is really very limited, notwithstanding that the Supreme Court, of course, you always need to know what the Supreme Court decides in any, about what the Supreme Court has said about any given provision of the C.P.C. But that's not what I'm saying. What I'm saying is, to get to know the law more effectively, you could for a moment forget the role of the Supreme Court and focus on the other courts in the hierarchy. What the Section 3 says is the High Court, the District Court will be, the District Court will be subordinate to the High Court, and the Court of Civil Judge and then Court of Small Causes will be subordinate to the High Court and will also be subordinate to the District Court. Now that's a hierarchy which we have to remember, because this hierarchy is what matters when we have to file appeals. Now, as I've repeated already so many times, a decree is one which is by default subject to appeal. Where would you appeal it? To appeal it, you must know the hierarchy very well. As I understand, the Court of Small Causes, the Karnataka Small Causes Courts of 1964, in terms of that law, the judgment or the judgment of a small cause court is appealed to the district court in all districts except the District of Bangalore, where the appeal is to the High Court itself. And under the Karnataka Civil Courts Act of 1964, a different arrangement is given as to what happens when a case is filed in, not in the district court, but then it is filed before a civil judge or a senior civil judge. Where can appeal go? An elaborate procedure is laid down there. So the hierarchy becomes very important, but hierarchy doesn't change from case to case. So once you clarify in your own mind about the hierarchy, you will find that it becomes a breeze. And I was telling you at the very beginning, C.P.C. requires a lot of effort in the beginning to understand it. But once you make that effort, once you spend some time, devote your time, valuable time, you will find that it's such a breeze afterwards. And Section 4 is, again, what you will find in the commentaries that you will find behind this. Courts have always struggled to find out whether C.P.C. applies with respect to proceeding taken under some other statute. And there have been observations made by commentators who say that a few of those judgments, influential judgments, forget to take note of Section 4 of the C.P.C. What Section 4 of the C.P.C. says is, where there is a special law, where there is a special procedure, where there is a special jurisdiction, and coming from some other statute, right? And there are other forums, then the C.P.C. will not apply, unless there is a specific provision therein which says C.P.C. will apply. This, unfortunately, is not taken note of by several influential judgments, and those influential judgments have influenced other judgments to start looking at, okay, let's look at the structure of this statute and let's find out if under the structure of this statute, if if CPC can make inroad or not. Unfortunately, that is not the proper approach. The proper approach is to follow or consult the CPC itself. Section 4 so very clearly says that you cannot fall if you're dealing with a special law, if you're dealing with a local jurisdiction, if you're dealing with a special procedure, if you're dealing with special power, then do not treat CPC as applicable to it unless and until there's a specific provision that says CPC will apply. And section 141 of the CPC says, it says that in civil courts, CPC may be treated as applicable. And that provision also says it shall not apply to proceedings under Article 226 of the Constitution. So when you read this first and then you read 141, you will find there isn't really a contradiction, because what this section 4 is telling is keep CPC out unless and until CP has been invited by a specific provision. And then section 5. Section 5 is a revenue, where there is a revenue court for that matter, and there is a revenue statute, and that revenue statute says for procedure that is not covered by, I'm just giving you an example, for procedure that is not covered by the revenue statute, the provisions of the Civil Procedure Code will apply. Let's assume this is a scenario. If this be the scenario, what the lawmakers here felt is, let's give a opportunity to the state government. We didn't have state government in 1908, but then as it is afterward, after 1951, let's give an opportunity to the state governments to say that even where the CPC is applicable, certain provisions will not be applicable, or should they be applicable, they will be applicable in a modified form. So that is what the states could say through an order by passing a special notification to that effect. Now, remember this, if a statute, let's say the Karnataka Land Revenue Act itself, says that in matters of procedure, which the Karnataka Land Revenue Act itself does not provide for, the CPC shall apply. Let's say it says so much. Now, the Karnataka Land Revenue Act is not a product of the Karnataka executive government. It's a product of the Karnataka legislature, our 224 MLAs who sit in the legislative assembly, and then the coordinate council, legislative council. So if by ordinary process, if the Karnataka government wanted to make a modification to that particular section, because this is always said in a section, made a modification to that section and say, notwithstanding that the CPC will apply, the CPC shall not apply with respect to this provision, this provision, this provision, and CPC will apply with respect to certain other provisions with so much of modification. If the state government wanted to do that, then it ought to basically request the legislature itself to modify the statute. But this is the provision under section 5 of the CPC where the state government is given this brilliant opportunity to not having to go back to the legislature, but then to come out with a notification that would say that CPC will apply in such modified form. So that's, I think, a far-sighted nature of what these lawmakers set out to do. I think we could agree on that. And section 6 is about the pecuniary jurisdiction. Now, it says, do not construe the CPC in such a way as to give jurisdiction to a court which does not have that pecuniary jurisdiction. Now, someone might ask, how on earth can we construe provisions of a CPC in such a way that a court that does not have pecuniary jurisdiction is given pecuniary jurisdiction? You see, you can think about fines, you can think about costs, you can think about men profit, and so on and so forth. Someone might come to the court, give me to recover possession of movable property, and then men profit. And then the court may find out that the men profit is much, much more than the subject value of the suit itself, because it was not known so earlier. So what this section essentially says is, do not read these provisions of the code in such a way as to confer pecuniary jurisdiction to a court which it would not have. And you will find it at several places in the C.P.C. where a court is empowered to impose a cost. Now you should know that there is a provision where a cost of 50,000 rupees could be imposed, where egregious, where something was sought by the plaintiff or by the defendant and on insufficient grounds, but the court in fact granted that, and later on the court realizes that there was no sufficient or reasonable basis to invoke it, then the court may impose a cost like even 50,000. And there it is said that it shall be subject, however, to the jurisdiction. So the court has to be mindful of what is the jurisdiction that it possesses. And section 7 and 8 talk about the provincial small cause courts, and section 7 is section 7 is about the provincial small cause court, and I will not be getting into that because as I've already said, the small cause courts law creates big trouble. A lot of eminent lawyers will have difficulty in understanding the jurisdiction of a small cause court, where it lies and where it does not lie, and we are expecting people with limited means to be able to appreciate the cases that are not subject to cognizance of the small cause court. I think this is a mess and something must be done by our lawmakers. Section 8 is again small cause courts with respect to the older chartered courts, and which again we will not be touching upon. And now we come to section 9, courts to try all suits, civil suits unless barred. Now, why is this there? The first question you should be asking is, no court is established by the Code of Civil Procedure, right? Why then is the Code of Civil Procedure talking about power of a civil court? And you should be asking this question. And if you have not asked this question to yourself, then I can tell you, you haven't been paying much attention at all. Because why? Why should the C.P.C. talk about the power of the civil court? It is not establishing any court at all. You look at the Constitution of India. The Supreme Court of India is created by a statute, by the Constitution of India. So who then determines the powers of the, ordinarily, it has been the practice that if a court is established by some charter, the power of the court is also laid down in that charter. Let's take the High Court, the Indian High Court Act of 1861. It was established by a letters patent, and then a few years later, the letters patent was modified to show the powers of the High Court. You come to the Constitution of India. The Constitution of India talks about establishment of a Supreme Court. And what are the powers of the Supreme Court? It talks about the powers of the Supreme Court. It also talks about the powers of the High Court, right? It says there shall be a High Court for every state, and the powers of the High Court are laid down. And it also says, notwithstanding that these powers are already expressly granted here, the government may, the parliament may always make additional law to confer additional powers on the courts. So the C.P.C. is not creating any court. It is dealing with existing courts. And why does it still talk about the power of the civil court? Well, to appreciate that, we must know that the C.P.C. has in mind that through other laws, civil courts will be established to deal with civil cases. And when civil courts are established to deal with civil cases, it so happens that you're not going to specifically talk about the power of the civil court in each and every case you establish a civil court. And with that expectation in mind, the lawmakers felt, let's talk about the powers of the civil court, and then they explain it in vast terms. They say courts shall have jurisdiction to try all suits of a civil nature, unless their cognizance is expressly or impliedly barred. Now the word statute is not here. So something might be expressly barred or impliedly barred. It may not be a statute. It might be something less than a statute also. It could be also even be a regulation. Now the meaning of this is this. The meaning of section 9 is If you have a civil claim, then the civil court's doors are open to you. And if the civil court's doors are not open to you, somebody had give you a better reason or a good reason why the civil court's doors are not open to you. And the first question you might have in your mind is, should I first ask which is the law under which I get the right to sue? No. You see, your civil right to sue is your common law right to sue, which we've followed for a long time. And for that, you don't need a statute. If somebody, if you are some person and somebody, defames you, you can sue that person on a suit of defamation. And the court might ask, look, you have come on a suit of defamation. Do we have a defamation act in India? No, we don't have a defamation act in India at all, not for civil cases. For criminal, yes, we do have defamation, criminal defamation under IPC 4, section 499 to 503. But to sue in a civil court, you don't need any specific statutory permission or any specific statutory enabling. Your right to sue is available to you by virtue of your civil relationship with the other members of your society. And once you have a civil right to sue another, if the doors of the civil court must be closed to you, it is important for somebody to tell you why that should be so. And it is never inferred. It is always intelligently ascertained by reference to the provisions of some statute, the provisions of some regulation. And in this context, I can tell you that over the last 100 years, if we go back to 1909, when the C.P.C of 1908 became applicable, the cases in which you could have approached a civil court were far more wider than the cases that you can now approach. If you're dealing with company matters, if you are a shareholder, if you have trouble with the board of directors, or if you're a director, if you have trouble with the other members of the board, you would have come to the civil court, but you can't because of the Companies Act. Successive Companies Act have created their own tribunals wherein they will deal with it. If you can think about 500 different statutes or 600 different statutes that in fact have taken away what used to be the jurisdiction of the of the civil court, and have vested that jurisdiction in the tribunals and forums that they have created. But notwithstanding this, you can always go back to a civil court where whatever court that deals with the statute is deficient to an extent that they can't deal with your prayer, or even if they dealt with your prayer, they did not follow the statute. Now I can give you the example. I can give you a couple of examples that you will readily see in the commentaries. If it's a sales tax legislation, of course now sales tax is gone, GST has come in. If it is a sales tax legislation, and you find that, again, not now, but much earlier, if you paid taxes in mistake, or if you paid taxes which were declared later to be unconstitutional, or taxes which the government already had noticed that was unconstitutional, but yet collected from you and you want a refund, and the statutory scheme does not provide for any refund, but yet you go to the tribunal, you make a request and you say, dear tribunal, please apply your implied power and then please get me a refund. And then the tribunal says, I've looked into the provision of the statute. I don't find anywhere the power given to me to direct a refund to you. I'm so very sorry. Then you can still come back to a civil court, and you can come back to a civil court and request that, look, the taxes have been collected by the government. The government ought not to have collected it. It is unjust enrichment and I'm entitled to a refund of the tax. And the civil court will most likely entertain your suit. Remember, this will not be hit like we will, going forward, we will talk about res judicata and so on and so forth. It's not a suit. What you filed before the tax tribunal was not a suit. So it will not be hit by the process of res judicata as well. So section 9, and then section 9 has an explanation 1 and 2. Now, explanation 1 and 2 both talk about, they are there largely to deal with so many judgments that had come out long back that said if the civil suit involves question wherein the court has to get into religious rites and ceremonies and then decide questions of religious rites and ceremonies, will it still be a civil suit? In that context, this explanation has been added to say where property or office is involved in a civil suit, but in order to determine the right over that property or office, the court has to also decide questions of religious rites or ceremonies, then it will still be a civil suit. And then explanation 2, you could generally ignore, but it's important. Section 9 is an extremely important provision of the C.P.C. So in the interest of completeness, you might want to know that explanation 2 deals with cases where while explanation 1 kicks in, but then the person concerned does not take a fee or he takes a fee. So in that regard, it says it is irrelevant whether a fee is attached or not to the person who's come to the court. Now, section 92 of the C.P.C. talks about public charities, and it says where there is a public trust, that's a religious or charitable in nature, and where there is a breach of the provisions of that trust, or where it appears that intervention of the court is necessary, then the Advocate General may, or for that matter, 2 or more persons that have an interest in the trust, not that they are involved in the trust, they have an interest in the trust, then they may approach the court on a suit with a view to secure several reliefs that have been enumerated there. The reliefs could be removal of a trustee or appointment of a trustee, and then requiring a trustee that has been removed to turn over the property of the trust, then to require the trust to recover property that it might have lost, or for that matter, to approve a different scheme, or then to say how the trust will be run in different ways. So when you're dealing with a religious trust, obviously questions of religious rites and ceremonies might come into the picture, and now you can really connect with the section 9. And I also want to say another thing, which is if you start reading the C.P.C, you will know that you had better keep the commentaries out of your picture. To get a good hold of the C.P.C, keep commentaries out. If you keep commentaries out and you start reading the C.P.C, you will develop questions in your mind, and you try to answer those questions based on a further reading of the statute itself. Now, after you read the statute well, then please consult the commentaries. But if you start with the commentary, you're going to go haywire, because the commentary is going to say, this is what a particular judgment has said. Now, that question never arose in your mind, so you're going to get lost. And I can give you an example. I can give you 1,000 examples. Section 16 basically says, of the C.P.C, again, all references to the C.P.C only. And it was never, ನಾನು ಅಂದ್ಕೊಂಡಿರ್ಲಿಲ್ಲ, in fact, section 9-10 ಒಳಗೆ ನಾನಿವತ್ತು ಹೇಳ್ತೀನಿ ಏನ್ ಮನ್ಸಲ್ಲಿ ಅಂದ್ಕೊಂಡಿದ್ದೆ ಅಂತ. 158 sections of the C.P.C ತಲೆಯಲ್ಲಿದೆ, and all the orders ತಲೆಯಲ್ಲಿದೆ. ಸೊ ಇದನ್ನ ಹೇಳಲಿಕ್ಕೆ ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ಅಂತ ನಾನು ತಲೆಯಲ್ಲಿ ಹಾಕೊಳ್ಳಿಲ್ಲ. ಸೊ ಹೇಳ್ತಾ ಹೋಗ್ತಿದ್ದೀನಿ ಅಷ್ಟೇ. That's what. I'm so very sorry. If people expected that I would have given a bird's eye view, I would have loved to, but then you see, bird's eye view is again, it's I thought this is a bird's eye view. You see, I'm taking a provision, I'm trying to connect it to some other provision, and then telling you why that provision is important, and why getting to know that provision in a chronological order will help you a lot. So I'll of course, as and when I am asked to, as and when I am interrupted, I will, until then I'll go. You see, section 16 of the C.P.C says where suits can be filed with respect to different subject matter. Section 16 says, if the suit is one where relief is with respect to immovable property in terms of you want to recover immovable property, maybe you ask rent or profits, or you don't ask rent or profit. If you want partition of immovable property, if you want to sell, if it's a mortgage, if you want a foreclosure, redemption, or sale of immovable property, if you want attachment of immovable property, or as far as movable property is concerned, where movable property is under attachment, previous attachment, you want some relief with respect to that movable property, then you may file the suit within the territory, within the court, in the court, within whose local territory the property is situated. Now, this is section 16. Now, if you really understand it well, you made a lot of progress. But you open up a commentary, it will start, the first thing that will say is, however, suit will still have to be filed where immovable property is situated. It can't be filed in a court within whose territory immovable property is not situated. Now, you should not be reaching that question now because you're still at the preliminaries. But then the commentary has given you a very complicated issue, a ruling of a court on a very complicated issue. And the moment you read that complicated issue, you're going to get lost. You're going to feel, wait, why do I need a conceptual or academic understanding of this? What is my case? Let's focus on my case. And that way, you would be deprived of a wonderful opportunity to conceptually understand the provision. So that is why I would request anybody that is serious about getting, C.P.C, getting into a deep understanding of C.P.C, keep away the commentaries and read the statute as it is. And after you read the statute several times, then go over to a commentary. And also there is a website known as archive.org, archive.org. Here you will find all the previous books that have gone out of copyright and all that. You could actually open up the commentaries on the 1859 C.P.C. You could open up commentary on 1908 C.P.C. that was given then. Because, and then you will find there are excellent books that will in fact help you to get a better view of the statute than the current commentaries. And that's my complaint about the current commentaries. They're not really, helping the reader have a conceptual understanding of it. They are, they muddle it. They muddle it by bringing in too many judgments. And then stay of suit, section 10, I finished section 9. Section 10 is stay of suit, where a court is presented with a suit in which the matter in controversy is directly and substantially also the matter in controversy in a previous suit instituted by the same parties or by others claiming under them, then in that event, this court is going to stay the trial or the suit. I mean, they're not going to move forward. And there is again a lot of, if you open up the commentaries, you will find that different commentaries give you different examples, and you might start wondering what's the objective of section 10, stay of suit. If how can someone file two different suits and then have the same issue directly and substantially? And in that regard, like I was telling you, if you go back to these commentaries written 70, 80 years ago, you get better examples. And rather than the current books, in which if you read the current books, they will muddle you. But broadly speaking, the meaning of the section 10 is, while the C.P.C already provides the opportunity to join several causes of action in one suit itself, there could be a possibility that the cause of action in two different suits is different. And section 10 is not talking about the cause of action. It's talking about matter directly and substantially in issue is the same. So while the cause of action might be different, the factors or the facts which led to that cause of action might be really very similar between two different suits that have been filed by the same parties. In that context, what it says is, if a court is presented with a suit that has these characteristics, it will have to stay that particular suit. And then we'll come to res judicata. And in the context of section 10, again, there's an explanation that says, if a cause of action is pending in a foreign court, that doesn't prevent you from filing on the same cause of action in India. Now, that's quite a concession. If you look at the way the C.P.C is structured, summons can go out. I mean, you will be serving summons also that have been issued from a foreign court. And there is so much of committee that we have. But yet the explanation to section 10 says, if a suit is pending in a foreign court, then on the same cause of action, you can still file a suit in India. And section 11 is the concept of res judicata. Res judicata means what has already been decided. Now, what's the principle behind res judicata and what happens if we did not have section 11 in the CPC? Now, that's something we have to focus on. If we didn't have CPC, and if I can give an example, somebody files a case, a plaintiff files a case, it is decided in a certain way, and then he files another case, slightly covering up the cause of action, slightly modifying the facts, and slightly giving a different twist or color, and then says that was a decision on different things. Now this is a decision I want on a slightly modified circumstance. Now, if the court were not to be guided by the statutory bar of res judicata, there is every likelihood that the court could entertain something and then later on find out that, hold on, this we should not have entertained at all, because there should be an end to litigation. End to litigation, number one. But how much ever we want that there should be an end to litigation, we should also know that there should never be a dragging of litigation as well. And what we find today is, if you connect it to the illustration I gave about what was happening in the princely state of Mysore, tens of thousands of cases were filed even back then in 1881, 1882, 1883. And 96% of these cases were disposed of within 3 months' time. Now, if you have courts that can deal with the matter in such a manner, now what was the population? Now, someone might say, what was the population at that point of time and what's the population today? Now that population, the increase in population is different from the increase in workload of our courts, because you will find that what was the population of India in 1947? From what I understand is, just at the time of partition, just before we created Pakistan and Bangladesh, and you should know that these laws, the data that we get for those days for the unified India, for the combined India, I think it was something like 39 crores, 70 lakhs. 39 crores, 70 lakhs was the population of India in 1947 on the eve of the partition of India into Pakistan, West Pakistan and East Pakistan. So if you look at the pendency of cases then, and then the pendency of cases now, you will find population has only increased by threefold, fourfold, not threefold, 4.5 to 5-fold. But the cases have increased unimaginably. So res judicata essentially says no court shall try any suit or issue the matter in which is substantial, directly and substantial in the former suit between the same parties under whom they claim, and which has been decided in a court of competent jurisdiction, and now it has been raised in a court which is again a court of competent jurisdiction. So broadly speaking, I truncated the actual word of it. I just gave a broad overview of the res judicata provision itself to say it means where a court is presented with a suit or an issue, the matter where directly and substantially was the same as was decided in a suit earlier between the same parties or other parties claiming under them or litigating under the same title, and it should have been heard and decided in the former suit. Now, after having given this overview in section 11, there are these explanations. Now, these explanations will in fact go to amplify the doubt some of you might, not some of you, any reader might have. Like they say that there must be two suits anyway. To really worry about the concept of res judicata, you must have a suit that has already come and is being decided, and a suit that comes later. Now, should the suit that has been decided earlier also be the suit which was instituted earlier? Not necessary. Not necessary at all. And someone might say, how do we connect this to section 10? Because I was saying in section 10, commentaries will practically confuse you and say that where the cause of action is the same, even then you can't proceed. But my view, my understanding is, though section 10 talks about cases where cause of action is not the same. Now, section 11, explanation 1 basically tells you that it doesn't matter when the former suit was filed, it doesn't matter. It is not required. It should have been filed earlier in point of time. And then another explanation says that the court of competent jurisdiction that must have decided the previous case. Now, why is this there? Now, let's imagine for a moment that let's talk about a marriage scenario. Matrimonial issues are kept out of civil courts, as you're more than aware. I mean, ordinary civil courts of ordinary original jurisdiction, as we understand under the C.P.C, they don't deal with matrimonial cases. Matrimonial cases are dealt with by other designated class of courts. So let's assume for a moment that parties were in ignorance. They come to a district court and then they file a suit for divorce, and then it is decreed. And one party opposed it, one party wanted it. And then the parties realize their mistake. One of the party realizes the mistake, and then what are they required to do? Now, if a court has no jurisdiction in the first place, if they don't have subject matter jurisdiction, you might as well treat it as a nullity. But in real life, I mean, that's what we find in all the books and all the treatises. But in real life, it so happens that, very often you can't ignore something like that. So if if this very issue were to be presented to a family court later on, the family court cannot say that, oh, hold on, the civil court has already decided this issue. There is already a decree, one way or the other. That is because the civil court did not have jurisdiction. So an issue that has been presented subsequently is not hit by the bar of res judicata. So what the explanation then says is the competent court, whichever has decided, there is no requirement that it must have been subject to an opportunity of appeal. Again, it does not say that it ought to have been, that it was never appealed and the appellate court never tested. Now, these are the arguments that the lawmakers have seen were made in cases long ago. And these were the arguments that seemed attractive enough to some judges that they did express doubts whether in such circumstances the concept of res judicata could even be applied. And you will find that every explanation that you will find against Section 11 is an explanation that's come with a view, with some judgment in mind. I mean, the lawmakers had some judgments in mind. So the fact that the competent court which decided the previous suit, the decree therefrom could have been appealed but was not appealed, or the fact of the decree thereof could never have been appealed is not a consideration, and it matters not at all to decide that if it is res judicata, it will be res judicata. And the next factor is, which again comes in the form of an explanation, is that an issue must have been raised, alleged by the one party and denied by the other party, either expressly or by implication. Now, imagine a scenario where a plaintiff says so many things that are not really required for him to seek the relief that he wants. Now, in this context, you should also take note of the salutary rules that we have, which say that the plaint should state material facts and should not contain the evidence itself. The plaint must make the allegation or present the cause of action by explaining, by describing facts that have led to that cause of action without presenting the evidence itself, right? But if somebody does not take note of this and then says so many things that were strictly not essential, and the defendant also in that case goes on to say so many different things, and then it's not so much like what was alleged and what was denied. It was like the court, the court felt that to seek this relief, it is enough if I deal with 2 or 3 of your allegations and 2 or 3 of the denials or defenses. Rest of it doesn't matter. So imagine a scenario like that. What the provision here says is, to find out if a matter was directly and substantially in issue, please confine it to those issues which were alleged, which in fact were alleged and which were also denied or objected to by expressly or impliedly. That's what is said. And the other important factor is, any matter or any ground that you ought to have made but you do not make, and any defense you ought to have taken but which you did not take, is deemed to have been made and raised in that matter. Now, this is required because if you file a suit on a certain cause of action and you do not allege certain things that you ought to have alleged, then it is taken that you alleged it and then it has been dealt with and decided already. And we'll come to the next explanation. The other one is if you claim a relief in the plaint, but then the decree does not make any specific mention of that, then it is deemed that the decree has refused it. Again, remember, if let's say you seek recovery of immovable property with men profit, and then the court says, take my final decree, you are entitled to the relief of possession of immovable property, period. End of the story. If there is no reference in the decree to whether you are entitled to men profit, then this provision says that it will be treated that you're not entitled to it. That is, it has been refused because you sought it in your plaint, but it has been refused. Can you then file a suit saying that I had sought 2 reliefs, I was given 1 relief, but I have not been given the other relief? No, you can't file a suit because it will be hit by the doctrine of res judicata. And in this context, I will slightly digress to Rule 2, framing of a suit. Now, framing of a suit is so much critical in our understanding of litigation. If you look at Order 1 of Rule 2, which says, every suit shall be framed in such a way so as to afford decision between the parties so as to bring a finality to the litigation and to prevent further litigation between the parties. Now, it is very unfortunate that Order 2, Rule 1 is something on which we don't find many cases. But if we look into it more closely, we will see that it in fact takes care of so much of mischief, or it tries to prevent so much of mischief we find these days in our court. Like I was telling you about family partition suit. Alleged family members file a partition suit, let's saying that this property is our joint family property, give us a declaration. And the court would say, okay, fine, I am convinced that it is joint family property, because why should I not be convinced? You are the family members, you are telling me. I give you a decree, and then you make use of that decree, and then you file another suit, bringing in all the various purchasers of that property, and then say that, no, that earlier suit was only a suit between our family members. And this later suit is a suit wherein we have brought in outsiders also. So where is the identity of the cause of action? They're entirely different. But take a look at Order 2, Rule 1. Every suit will have to be framed in such a way as to afford grounds for a decision and to prevent further litigation between the same parties. If this rule is present to the mind of the court would say, it's impossible for you to ask for anything more after you obtained that first decree. When you wanted that first decree, you only made your family members as defendants. You did not bring any other person from the outside. You did not even allege that family property has been alienated. In your plaint, you have said your family property is all with yourself. Now you can't take a contradictory stand. It would amount to perjury. So you have to be thrown out of the court. So in that context, I thought we could amplify it. And I would like to conclude this with thanks to the AILU. It's a great opportunity for me to have this occasion to address all of you. And I apologize if I have not held your attention, because I know how difficult it is in this case. But I think going forward, I hope that we will all have more occasions to meet with each other and then take this academic mutual learning together forward. Thank you.